welcome everyone to this webinar, and also welcome to you, Jens, and thank you for joining. I just want to quickly go through kind of a few practicalities and the agenda, and then we'll quickly dive into the introductions and then start on today's topic. Very welcome to everyone. We have around 60 minutes, and the agenda is a little bit flexible in that sense, depending on how much time we spend and how many questions we get in. Starting out with the quick intro of myself and Jens, and then really diving into the regulatory framework, the current regulatory regime, some of the notable and upcoming changes in the regulation, and then trends and recommendations, and then obviously also room for questions and answers in the end. You're more than welcome to ask questions as we go along, and then we'll save them for the end of the session, and just use the Q&A box. So the chat should be disabled, but the Q&A box is absolutely there. So please feel free to ask as many questions as you want. So with those words, I'm actually gonna let you, Jens, introduce yourself and welcome. Thank you so much for joining and giving us an hour of your time to talk about this. But I'll give you the honor to introduce yourself actually, and kind of what you've done, so people understand the significance of your career and more importantly of your experience.
Okay, thank you very much, Anders, and hello to you, audience. Good to have you all. So I'm Jens. So I work basically in the financial crime prevention area for the past 30 years. Initially starting out as a financial inspector with the Danish FSA, and then transferring into the State Prosecutor's office for serious economic crime, where the Danish FIU is and was embedded. I became a director of the FIU. After that, transferred to the Intelligence and Security Service. Worked for some interesting years, for example, during the years of the rise of the Islamic State in Syria and Iraq, and also the years of the terror attacks in Copenhagen. After that, the next stint was in the State Department, or the Ministry of Foreign Affairs, as we say more formally. As a counterterrorism coordinator, also still working in the field of terrorist financing and also counterterrorism as such. Those were very interesting times as well, because it was where ISIL was on the rise and where the caliphate was at its peak. So there was a lot of work with the Americans, obviously, but also with the Middle East countries, trying to understand the global flows of ISIL. Then I started reading newspapers, and so there was an interesting case apparently in its wake, including or involving Danske Bank. And I reached out to the former chairman of the board, teasing him a little bit, bringing a few papers and saying, by the way, how are you doing in this particular case? Estonia case, obviously. I think 10 days after, I had an interview with Anders. And against all odds, I had a contract within a couple of weeks. Worked there for some very, very interesting years, together with Anders and other colleagues, trying to understand what happened in Estonia. After some years, and I wouldn't say coming to a conclusion, but at least coming further down the path, I decided to create my own advisory. It's what I'm running today. I have some major clients. First of all, Plessner Law Firm, where I have a permanent office and colleagues, if you like. I think most people here in my corridor, they believe that I'm either an employee or a partner. I even get invited for parties, etc. So that's a good partner, obviously. I do basically 3 different things here. I do internal investigations, or run them in big corporates. I do advising on corporate criminal matters, also sometimes as a defense counsel. And finally, different sorts of advisory on anti-bribery, corruption, AML/CFT, sanctions, also for bigger corporations. I do also quite a bit of work for the European Commission, being my other big partner, if you like. I run and participate in a few projects under the European Commission remit, One is in relation to assisting high-risk countries in making sure that they, first of all, understand the international standards, but also comply then with the 40 recommendations of the Financial Action Task Force. And the other program or project which I'm running is specifically on understanding the AML-CFT risk affiliated with correspondent banking. Of course, that being a typology that we have seen also in some of the major money laundering cases across Europe and also the US over the past 10 years. So that's very much myself in a nutshell. Anders?
Thank you so much. So yeah, I think it's dwarfing to look at this CV, and so I think this is it's so interesting because you've come from kind of the regulatory legislative side, then moving into the enforcement side, covering both money laundering, terrorist financing, tax evasion, the whole scope of financial crime prevention, actually, right? And then moving more and more into the details, where we got to work together in Danske, looking very much, transactions case by case, how did it happen, root cause analysis, transactional reviews, and now you're utilizing all of that in your current role. I think it's absolutely amazing. So no, thank you so much, Jens, and thank you for joining.
Yeah, you're welcome. No reason to be amazed here.
So,
I think what Anders is trying to say is that I'm old. Well, that's quite okay.
Exactly. That's one of the benefits with getting older, right? That's experience, right? And getting to try a lot of stuff. So thank you, Jens. Very, very quickly about me. So I'm one of the co-founders and the CEO of Avallone. I've been doing that for almost 4 years now. And we're not going to spend a lot of time on Avallone. It's a technology platform for both responding and collecting what we call high complexity KYC. So how does enterprises share KYC and transparency data? Before that, as Jens mentioned, I had the pleasure of also working in Danske, heading up compliance during a very, very difficult time from 14 to 18, where we figured out what had happened down in Estonia, and then starting all these investigations and trying to get to some sort of resolve of that. Before that, worked 17 years in Nordea, also last 3 years as head of risk and compliance out of Stockholm, but actually predominantly corporate banking, so the more commercial side of the bank on the large corporate institutional clients. So I guess yes, the boring banker gone tech startup founder. That's me. But now we're here today to talk about kind of the regulatory environment, and we kind of split it into two topics: kind of the current regime, the current regulatory regime, and the second topic is kind of the impact of the regime. And we're going to try and split it more or less equal to both, but it may be that the first part takes a little bit more time because there's a little bit more, I think, foundational explanations in that. So I think we're gonna start to jump into the topic and going to this slide in terms of the overview. And I guess the question is just starting to ask you to explain kind of what's the overall regulatory framework between FATF, EU, etc. How does it all connect before getting into the details of what's actually going on there?
Yeah, and we're going to do a little bit back and forth also. Anders is going to explain a little bit more also on the sort of screening part. He has the necessary technical insight into that. But rightly, I mean, back to the regulatory framework, and what do we mean really when we say that? I mean, today our focus will be very much on AML-CFT because we promised also to address the Financial Action Task Force, which is exactly relating itself to that particular topic. But really looking a little from a broader perspective, of course, regulatory framework is much broader also when it comes to what requirements the corporates have to comply with. And, the boxes or pillars, if you like, on the screen are just 5 examples. I try to, list them up maybe in a logical way and trying also to give them a little rating or scoring in terms of the legal scope and the regulatory requirements. I mean, those are my own perceptions and my own opinion here. But let's start by the anti-bribery and corruption. I claim relatively narrow legal scope, meaning that, I mean, the entities and situation covered, hopefully, are quite rare. not that broad in scope, because hopefully corruption is not happening all the time. And also relatively basic regulatory requirement. I give a score, as you can see. The focus on transparency, know your supplier, is very much in the equation, meaning also that screening is quite relevant, because knowing the supplier, of course, screening very quickly comes into the picture here. GDPR, very broad legal scope, because you cannot do business or even be a private individual without having some sort of bearing on the GDPR regulation. Medium regulatory requirement, meaning, there's not that much you will have to do. Yes, you will have to declare that you own the data of the data owner, etc. But it's not super complex, but it's very, very broad in scope. The focus is on know the personal data owner and all the obligations and duties. Screening may be less relevant, or maybe it's only because I don't have the insight, but that's my opinion. Sanction, medium legal scope. It's not in any situation that the sanctions are relevant. It's in relation to particular individuals, countries, organizations. If we include export controls, then of course it's a little broader. Also the dual use requirements, etc. Also quite basic regulatory requirements. If you encounter someone subject to a sanction regime, then it's quite basic actually what you will have to do. You will have to abstain from having any sort of interaction with the person or the organization. Or if it is about financial sanctions, then you have an obligation to freeze, of course, any assets. The focus is on identifying designated individuals and entities, and screening absolutely crucial. Otherwise you would have all the time to follow all sorts of lists and legal regulations from EU, UN, US, UK, you name it. So that is very essential. On AML CFT, I say medium legal scope, because it's basically down to the obliged entities. And then very broad regulatory requirements. Those of us having worked in the financial sector, I think you will agree that we give a full 5 of 5 here, because once you're an obliged entity, there's really, really, really many different sorts of obligations that you will have to comply with. Focus on, as you know it, KYC, transaction monitoring, reporting, etc. And screening, I claim, also very relevant. For ESG, sustainability, which is very much the new creature, again, very broad legal scope, broad regulatory requirement. I think the data points that you will have to know if you will need to, or if you want to respect the newest EU legislation on this, it's 1200 plus, I think. On AML CFT, it's probably between 300 to 400. And as I'm sure you would know more about that. But it's quite substantial when it comes to the regulatory requirement. Of course, focuses on the specific data related to ESG. Screening, to be honest, I'm not sure. I don't know, probably quite relevant, but I think the future will show us more. Anders, anything from you on this? Now I took the liberty of trying to, give ratings and scoring on the relevance of screening for those particular 5 areas of regulatory regimes, but you could disagree.
No. I think this is super interesting, and I think what's also interesting is that in the context here we include both GDPR and ESG sustainability, right? Which really shows that you can't solve financial crime prevention without actually also having the others into consideration, and what's actually taking up a lot of energy and focus right now in the regulatory landscape, right? And then I think when we talk about scope and how many are being impacted of this, I think there's kind of a foundational box underneath, maybe even, where you can talk about reputational risk, right? That even you're not a legally obliged entity in CFT or CTF, you can still be a normal company, and then you miss something, or you deal with the wrong person, or you are involved with the wrong partner, and it impacts your reputation, even though you didn't as such breach any regulatory requirements, right?
Yeah, exactly. And the same goes for ABC, right?
Yes.
I state narrow legal scope. Yeah, true. If you look at the legislation, it's probably quite narrow, but anyone being exposed to this obviously would encounter a very, very difficult situation.
Exactly. And then I think the other part, usually when we talk about financial crime prevention, we have these five sub parts of it, which is bribery, corruption, it's money laundering, it's terrorist financing, it's tax evasion, and it's sanctions compliance, right? So I guess what's added here is GDPR and sustainability, and then not that it's part of financial crime, but just part of the regulatory overview. And then, of course, you have tax evasion somewhere in here in between, right? Maybe in AML, CFT. Yeah. Beautiful.
Okay. Yeah. But let's try to narrow down a little bit rather than looking at 5 pillars here. Let's focus on AML, CFT and sort of the global framework, or from global down to day-to-day business in the corporation. So we promised also to give the audience a little overview here. I mean, this is probably common knowledge to many of you, but we just wanted to show you here. We're starting from the top, the 40 FATF recommendations. Scope obviously broader than just a regulatory framework. I mean, it's not just on the prevention of terrorist financing and money laundering, but it's much broader. It's also on the penal and criminal framework. It defines also powers for law enforcement, for FIUs, international cooperation, etc. I was a Danish delegate for 15 years with the FATF, and I think one of my first meetings was in defining the first special recommendations on terrorist financing 3 weeks after 9/11. And then, of course, we have seen the situation evolving over the past 20-something years. I write global applicability. I mean, there's a limit to how many countries are members of FATF mother organization, but there are these regional organizations called FATF-style regional bodies that also has taken the obligation to live up to the same regulatory framework as with FATF. So in theory, global applicability, what is the binding character here? I mean, you can almost see from 40 recommendations, a recommendation is rarely something legally binding, right? But it's being perceived as legally binding and for sure politically binding. And even though some countries might come back and say, oh, it's just a recommendation, I mean, who cares? Then once they are being designated by FATF and on the gray or black list, I mean, I'm sure they will care because there are implications here. So it is being perceived surely binding. I write also level of detail. I mean, being recommendations, they are rather broad. I mean, they are much less detailed than the EU directives, for example. But if you go to the FATF website, which, by the way, is very informative, you can see with each of the 40 recommendations, there's a whole set of so-called interpretive notes that gives much more granular details on how to understand the individual recommendations. The European Commission has always been a member of FATF and still is. And of course, take whatever is being decided in the FATF framework and sort of transposes this into European legislation. So focus on risk-based approach, quick KYC, onboarding, ODD, etc. Of course, with European directive, there is a need for national harmonization, national implementation. You can see that on the right-hand side of the slide here, go one layer further down the pyramid. National AML CFT laws, being directives until now. There are national differences and not full harmonization. Even though, I mean, looking at the legislation of Denmark next to Germany, Sweden, and France, you don't see that big differences. But the argument now for actually changing the system that we'll come back to in a while is that there are national differences and also national differences in the way the supervisors work. And of course, the fourth level here is the obliged entities obligation. Take all the obligations and standards coming in, from the national laws, and there are many here obligations in terms of risk assessment policies, guidelines, etc., in order to implement AML CFT laws in the individual institutions. But Anders, I mean, on the I could maybe ask you one quick question here, also with your background, both from Nordea and Danske. I mean, the differences from jurisdiction. I mean, is that something that was, perceived important to your different positions? How do you see this? Maybe also the way the supervisors acted.
Yeah, I think so. Thinking back, when did I get into the dark side of banking? That was in 2011, probably, right? So 12 years ago, right? So just thinking back then, yes, there were huge differences between the countries and the supervisors, right? And I think it's fair to say that if you just take the Nordics, we've been on an immense maturity journey. I think overall, as nations and authorities and banks and sectors, we've been so naive in terms of what is actually the risk here, right? So I think both differences in the legislation, but even, for me, and that's probably because I'm not a lawyer, right? But for me, the legislation is even less important. It's important, but it's a minimum standard that's put out, right? It's a guideline of what institutions have to do and what companies have to do. But in the end, it's not a legal discipline, it's a risk discipline, right? So the goal is to avoid the risk of financial crime prevention, right? So there, I think we've also been on an immense journey of moving from a check the box, I'm doing what the legislation tells me to do, to a risk discipline where I'm actually doing whatever I can to do and what's reasonable to do in order to mitigate the risk. But I think also back then, there was a very open conversation around who were strong regulators and who were not so strong regulators, right? And there was extreme differences, which can seem like an advantage that you're operating in a country with a less strong regulator in this field, but it's actually not, because in the end, if you do something wrong, it doesn't matter whether the regulator is pissed off or not. It's you're doing something wrong and you get super hurt on your reputation, right? So when I'm then fast forwarding to today, I think there's much more alignment because we've learned so much, right? And apropos the Estonian scandal, I think there's so many bad things about that, but there's also good things in terms of maturing Denmark as a country, the regulator, the banks, the individuals involved. You learn so much from mistakes and incidents, right? So I think it's much more aligned now. And I think that's also when we look beyond Europe and the Nordics, you can, I think with all the conversations we have across the world with professionals, everyone understands FATF. Everyone is looking at FATF as this is where things start, and then there are regional differences. But the best practice, what's actually been done out there, starts to become more and more the same, I think.
Cool, Anders. And with the differences, I mean, you would never know which standard really to apply. That's also, of course, difficulties operating as
No, exactly. And we work a lot with KYC, of course, which is just one control, it's one mitigant, right? But the most frustrated people, they're like, why isn't there just a list of things I have to do? And of course, there's no list of what you have to do because it depends on who you are as a company, what's your risk, what's your counterparties you're trying to understand, right? So there's not one solution, but there starts to be best practices within the industries and within the risk profiles that becomes more and more predominant, right? Yeah.
But maybe before we jump to the future, let's look back quickly, Anders, on sort of some of the major regulatory changes
Yes.
over the past few years. And we should say also to the audience, I mean, we have quite detailed notes here that we can share with you after the meeting, but we're not going to put that very detailed PowerPoint because it's going to kill you, but it might be useful to read afterwards. So maybe just a few highlights, from the biggest regulatory changes over the past 5 to 8 years. If we go back 10 years, then actually there was a big stock-taking review by the FATF of their own recommendations. They fully integrated terrorist financing in the preventive framework. They introduced also for the first time in writing the so-called risk-based approach. That was a novelty. by then. They added tax crime very importantly as a predicate crime, and they also added more emphasis on corruption, for example, by introducing enhanced due diligence measures on domestic PEPs as well. Beforehand, it was just international PEPs. A couple of years later, in 2016, FATF took further new action in revising the recommendation 8, which is on the NPOs, non-profit organizations, in order to make sure that NPOs generally could not be misused for the purposes of terrorist financing. There are some, detriments to that, to be honest, that we can address a little later. With that stock-taking review from FATF, also EU Commission has always followed up in 2015, 2018, 2 new directives. 2015, basically implementing into the European context, the new 40 recommendations. And then 2018, further tightening the regulatory framework through a number of new regulations or provisions in the 2018 directive. One interesting provision being on cryptocurrency with more stringent controls, including requirements on CDD and also on SAR reporting. An obligation for the member states to have a UBO register was actually introduced in 2018 with that directive. With FATF, it came only 3 years later. So that's normally should be the other way around. But it's only a couple of years ago that FATF actually changed its recommendation 24 to have a specific requirement to have a national register. Beforehand, it was a more open obligation for countries, to have a regime in place by where law enforcement were able to access the information, but it didn't call specifically for a register. It does now. With the 2018 directive, also requirements to have publicly available PEP lists. Furthermore, enhanced due diligence, including source of wealth investigation for customers of high-risk third countries. So introduction of a number of interesting new provisions. I forgot to mention one interesting provision, at least I believe so, from 2015 directive. It provides a legal basis for the European Commission to designate high-risk third countries through so-called delegated regulation. Normally, a regulation would have to be adopted according to the normal decision-making process with all 3 EU institutions. But with this legal basis, the European Commission can issue so-called delegated regulation designating a country as a high-risk third country. That is quite interesting. That happened in 2015. And then there has been, an evolving when it comes to the number and specific countries actually being designated by the. Yeah, I think that's I guess probably looking back. Yeah.
And as you say, we're going to share in the slides. There's a really good list that you made in terms of these changes. I think maybe 2 comments. One is the whole notion about risk-based approach, I think, is a massive beast in terms of putting it into regulation, but also the understanding and the maturity of making sure companies and institutions understand that it's not about performing the same controls on each and every one. It's really about focusing your efforts on the most high-risk part of your population, whatever you need to mitigate, right? And I think that's going back to basics in terms of risk management. Risk management is resource allocation, and this is also what risk-based approach is, right? I think the other one that is super interesting is the whole NPOs, charities, because they have massive problems with the de-risking by the banks, right? Because they are inherently pretty high risk, so it requires some courage to deal with NPOs. On the other hand, they work with so important stuff, right? It's a little bit ridiculous that the organizations that's trying to help people in need are being misused by especially terrorists in terms of terrorist funding, right? It's really disgraceful in many ways. So I think that's very important also to work on. But there's one question, Jens, I came to mind, is you mentioned the national UBO registers. It's funny also, and also you started out by highlighting GDPR. So now we see GDPR and AML conflicting in laws, right? Because in Germany, they've deemed it illegal to actually have the level of detail the UBO register has, because you're breaching GDPR requirements for the individual, the UBO, right? So it's a little bit like, hey, hang on, guys, we're trying to create transparency, and then we have this other regulation where we're trying to protect the individuals. What's your thinking around that one? I know it's a little bit off topic on the GDPR part.
No. I think we can try to juggle off topics. Actually, it's not just the German timers, because it's at EU level, because there is a ruling from the Court of Justice, the European Court of Justice, from November 22nd. I remember the date because it was quite, there was a lot of fuss on the internet about this, on LinkedIn, saying this was a huge setback for the fight against financial crime, etc. Because the European Court of Justice came out with a ruling saying basically that the provision in the 2018 directive was invalid. The provision allowing any member of the public, as I said, to have access to the content of the public registers. There are 3 levels of access, to those UBOs registers. One being law enforcement, FIUs, authorities obviously have access. Secondly, those who will have to comply with being obliged entities, those subject to AML, CFT legislation, obviously also need it. But then in 2018, as opposed to the 2015 directive, it added a provision saying any other member of the public can at any given time get access to the register and get whatever data. That was last year, November 22nd, deemed as a disproportionate provision by the European Court of Justice, and that provision was deemed invalid. It doesn't mean that it's now completely impossible. It just means that if you're not in the category of either being an obliged entity or being an authority, then you need to demonstrate a so-called legitimate interest. And that was the wording of the 2015 directive. How that's going to end,
exactly.
I don't know. And I haven't, tried to approach the Danish ejer register, the UBO register in Denmark, and pretending to be, a third party demonstrating my legitimate interest. And if there are any sort of control questions, that there's probably is, because now the ruling has been in place for a year, so they need to having done some sort of adjustments.
Yeah, and it opens up for myriads of questions, right? Because then what about the public data providers that go in the public databases and retract data? How can they then make sure that this data is ending up in category 1 or 2 and not in the third category, right? And then what is, so I would claim anyone, regulated and unregulated, have a, of course not a consumer, but any enterprise have a legitimate need to understand the ownership structure and the UBO details, right? If they want to understand the risk and they want to screen to a sanction screen to a certain level of certainty, right? But very good.
But that created a lot of fuss also, and the reason of which then the European Court of Justice, as an exception, actually a few weeks after, issued a memorandum, which you can probably find also on the internet somewhere, trying to explain, what would it take to demonstrate the legitimate interest? In other words, to calming down people and saying, it's still pretty broad, but it's not a completely open door.
Exactly. Yeah, and I think at least what in Avallone, which we felt was an enormous frustration among current and prospect customers, because they were hoping for public databases to be more open, so they didn't have to be disturbed so much, their UBOs and disturbing other UBOs. But now what's happening is that in order to make sure you go directly to the person or the company and say, you need to give us all these details on the UBOs, so they don't go into the register, they go to the source, right?
Yeah.
But Jens, should we maybe in the last part of topic 1 talk a little bit about the future, what's coming, and I'm specifically curious around UBOs actually, thresholds and stuff like that. But I leave it to you to prioritize the most important.
Yeah, a very quick overview maybe. From FATF, there's no big new stock taking review in the horizon, but still they do interesting work. On the NPO, for example, they have a public consultation paper out there, also, to count some of the sort of detriment consequences or unfortunate consequences of normally per default being categorized as high risk. So there's some work there. Also some work in relation to the real estate sector, which can be interesting, realizing they're probably not submitting very many SRs or STRs. But what's really kicking is on the obviously on the EU side, where we had now a couple of years ago a big new draft EU package on AML-CFT, on sort of on the back of all the EU scandals, if I allow myself to call that we had the past years across Europe. And one of the arguments being, in the aftermath of that and trying to analyze what actually happened, were also these national differences in the level of supervision from the supervisors, but also the level of understanding, of course, with the obliged entities of risk, etc. So there's a whole new package on the way. There's a new regulation on a new supervisory authority at EU level called AMLA, Anti-Money Laundering Authority, which is going to have some crazy powers. For the real big institutions, so-called selected obliged entities operating in for credit institutions in 7 member states. So the really big ones, the AMLA is going to have so-called direct supervision, meaning they can push aside the national supervisor under certain circumstances and do the direct supervision. Then there will be a direct regulation. So what is in the directive today when it comes to the preventive framework on obliged entities, so everything in relation to KYC, CDD, reporting, all the rest, that will go from directive to regulation, meaning that it no longer needs a national implementation because a regulation has direct effect in the member countries. And that leaves no space, of course, for then, national differences, or at least, of course, the European Commission also. There's a lot of very, very interesting details here. Also an application to create new national registers for, today we have on real estate, we have UBOs, so on companies, but on other big assets like boats, cars, many countries do have already, but it's not a formulated or formalized application in the legislation, and it will probably become so. To your question on UBOs, Anders, let me just make sure that I have my notes here. So where are we on the package and that particular question on UBOs? I mean, in the current directive, there is not formulated a threshold. We have in Denmark, we say it's 25% plus ownership or similar interest, but that stems, from guidelines coming out of the company agency, and I mean that is what corporations tend to implement. So of course it could be interesting if actually the EU was coming out with a specific threshold of what would constitute ownership. In the first draft from the Commission, there is none. There is not, such a defined threshold. And the same goes for the Council position, which was published on December 7 last year. But during the spring, in March, the European Parliament published their position. And they are more specific, they go more directly on trying to define the threshold. And what they say is that and just to hold tight here, it's the European Parliament position, so it's not law yet, it's not binding yet, but it's their position, saying that beneficial ownership should mean having 15% plus 1 share, so 15% plus, so above 15% ownership of voting rights or other direct or indirect ownership interest, and then going down even to 5%. Plus 1 share, so above 5%, in the extractive industry, so singling out one particular industry, or if we're talking about a company exposed to a higher risk of money laundering and terrorist financing, without the latter being defined. So, the general rule, if you have more than 15% ownership, and in some, particular high-risk situations, if you have more than 5% ownership. Yeah. That's the position of the European Parliament. Right now, there are ongoing so-called trilogue negotiations between the three: the Commission, the Council, and the Parliament, and they are trying to come out with a joint position. I mean, there's nothing about what is the potential date for this? This is what we see.
But that's gonna, if that happens, it's gonna have huge implications, right? Because you're moving, because I think 25% is more or less across the world than the normal risk threshold, right? And then you bring that down to 5, and then for high risk you bring that down, to 15, then you bring high risk down to 5, right? That's just a huge amount of transparency that needs to happen there.
Yeah, you can, I mean, you could argue also, are we talking about ownership? And I mean, because you're sort of watering out a little bit the concept of ownership. But it provides a lot of transparency, that is for sure. And it provides a lot of additional tasks also for the industry who will have to comply with this.
Yeah.
That is equally for sure. But there's a lot of footwork still to be done here, you know, on agreeing, obviously, on the threshold. And then if the institution come out and say, okay, for high risk categories, we define a 5% plus requirement, then of course they need to define also what are the high risk, etc. So it's probably still work for lawyers here.
Yeah, exactly. And but I think also, so I think, so it's not as if we're moving from 25 to 15 to 5, because I think most mature tier 1 banks, they're working on a 10% threshold if it's a high risk client, right? But just bringing that down to 5 will have a big impact, right? So okay, but that's going to be super interesting to see. And even so, I think it's more now that the regulation is trying to catch up with what is actually the practice out there, right? And then making it even more strict, which is interesting.
Yeah.
But Jens, do you have anything else on the future, or should we just, in the respect of time, quickly jump into to the second part, which is which more the impact?
No, yeah, let's do. I mean, we talked about one focus point would be to look at which industry could be mostly impacted also.
Yeah.
From what we see coming. And I mean, with the EU, obviously, I mean, we're not there yet. I mean, this is still being debated with the 3 institutions. But also talking a little bit about trends, what we have seen over the past 5 years, and maybe same sort of trends going to continue going forward, then there seems generally to be, in favor of an avoidance of the use of cash, for example. There are declaration requirements for if you carry amounts of cash and the threshold are going down. Also, general attention on dealers in high value items, even potentially new public registers, as I said, when it comes to cars, boats, etc. Valuable assets in free trade zones is also being defined specifically by the European Parliament. Pretty much attention on crypto virtual asset providers. And one of the 4 legal instruments in the draft package from the EU from 2021 was actually to add also virtual asset service providers to the PSP regulation, realizing that virtual asset providers also do payment services. And that part, a small change to the PSP regulation, has actually been adopted already as the first of the 4. So that is quite interesting. That's probably a move that we will see continuing the focus on crypto currency or virtual asset providers. My guess is also there will be, a continued focus on industries with the low number of STRs and SARs. For sure, FATF is now looking at the real estate sector, and there are other sectors who are not submitting very many reports. Working in a big law firm, it's quite transparent here. Of course, you can go to the Law Society and look. I mean, how many reports from Danish lawyers, for example? Not very many. There are more reports from other institutions that involve lawyers than actually reports coming from law firms. Also, I think there will be a continued focus on banks with customers in high-risk third countries. And then once we have this new supervisory authority at an EU level in place, then that authority needs to start working, defining the different risk levels, so a further harmonization and understanding the different risk levels, but also for the real big credit institutions, as I mentioned very briefly before, the so-called direct supervision under very particular circumstances where the EU supervisor can push aside the national supervisor if they're not happy with what they're doing. So that is what we see ahead in terms of impact on industries. Maybe if we
could share maybe some recommendations, right?
Yeah. Just quickly, and as I said right before, I mean, we're going to share also the slides here. So in terms of recommendations, these are strictly, my personal recommendation. Follow closely and implement new regulatory requirements. For example, follow the revised so-called what do they call it? The regulations from the EU on high-risk third countries, because they are evolving all the times. There are new countries being added, so it's important to add that to your screening mechanism. Implementation of a risk-based approach. You mentioned, Anders, on NPOs. If we go back only a couple of months ago, if you, in Denmark, for example, heard the national risk assessment from the Intelligence and Security Service, NPOs were per default categorized as high risk, which obviously gave them all sorts of problems, or at least topics, when approaching financial institutions, and also pretty difficult for the financial institutions. Now there are guidelines out there, but much more work needs to be done. It's only 2 days ago I saw the chairman of the Bankers Association also calling for further political actions on this. Equally on correspondent banking, there's this tendency of de-risking rather than trying to understand the risk of the respondent bank. For those of you who are not super familiar with the concept of the correspondent bank, we added a little diagram here. For example, myself being the sender, I want to send money to Anders being the receiver. He's a Chinese citizen, by the way. And I'm using my own bank. I go to my bank. Anders has his Chinese bank, but they don't communicate. They don't have a working relationship. So we need to use a third-party bank, a correspondent bank. But that bank is only familiar with my Danish bank. They don't know me. So of course there's an inherent risk here. But rather than closing down the relationship with Bank A, then my argument here is that the correspondent bank should try to understand the risk. Do Bank A actually take AML/CFT risk seriously? And do they have confidence in Bank A knowing me? Focus also on effectiveness, not just formal compliance. And then, very much when it comes to banks and other credit institutions on the transaction monitoring, I call it the feedback loop, trying to adjust also the risk assessment the institutions are conducting on the basis of the output from the screening and the transaction monitoring. So if it turns out that, on the basis of the defined scenarios in the system, very good very interesting money laundering cases are actually being surfaced, then you need to take that into account next time you revise your risk assessment. I think I'm going to stop here, Anders, because we need to save a little time.
Yeah, this is super good, and I think so. Obviously, correspondent banking, we are, I guess, in the most complex end of financial crime prevention, right? Because they're trying to understand, the control mechanisms each bank has in place, and how well do they know in this part the sender and the receiver, right? But I think this is going to be more and more common as also fintechs arise and new banking arise, and the whole payment infrastructure is being disrupted in many senses, that more and more banks need to understand these other financial players, and more corporates will also start to understand each other, what is actually the mechanisms they have in place in order to know their customers or vendors, whoever that is, right? So super interesting developments. Hey, we have a few minutes left, and there's one question I would like to forward, which I guess is a question to both of us, Jens, coming from the audience. So there's been a lot of talk the recent years whether regulators, and I'm trying to see from a regulatory point of view, but whether regulators will start to require automation. Because I guess in principle, you can work yourself out of any problem. You can hire people, to do things manually. Mm-hmm. But do we think that at some point automation becomes a direct requirement, that there's simply no way you know, I guess depending on your size, that you can convince a regulator that, hey, no problem, we're going to do it manual all the way? Kind of what's your initial stance on that, Jens?
For sure, it's an evolution. I mean, it's difficult to say, Anders. I mean, I can give you one example on use of AI in the handling of alerts, for example. I run a AML CFT network for specialists in the financial sector together with a couple of other persons. And we had a very bright guy who's running an AI business and trying to integrate some of his solutions in the financial sector. He gave a presentation during our last network meeting, and we had a good discussion. And some of the participants of the network said that they were in dialogue with the Danish FSA in how they actually could use AI. If we take the transaction monitoring and then alerts coming out, then for the handling of the alerts, they wanted to use AI so that what is coming out from the alert actually can be compared to the entire population of transaction using AI. And that is not something for sure you can do manually, even though despite how many people you hire in your corporation. So I think it will come. I think the FSA will for sure for a long time, still insist that there will have to be a human eye on anything that is being sent to them in terms of controls and reporting. But for the extraction of the data and for making sure that, for example, an alarm is being, held up against the entire population of transactions or data points, etc., in an institution, I think it will probably be a requirement. If not a defined requirement, then indirectly defined, because there will be obligations that would make it impossible not to use.
Yeah, exactly. No, exactly. And I think it also depends on your complexity, right? We've met, small funds. They have maybe 100 customers/investors, and can you realistically convince the regulator that you can do this? You can do the KYC on them manually. Yes, you can. It's actually doable, right? You onboard them one at a time over a number of years. With 100 clients, maybe a couple of clients will pop up every day, not even maybe every week, right? It's absolutely doable, right? So it's also about the volume of it. And can you then, go in and check on the sanctions space once a week? Yes, you can. But then do you want to do it daily? Do you want to do it monthly? So I think as technology evolves, there will be less and less excuse not to use it. And it wouldn't make sense either from efficiency and effectiveness viewpoint, because I think it's coming back to risk-based approach and managing your resources. So if you can have technology to do part of your work and automate it, it means that you can spend your time on other stuff, and that other stuff is actually really focusing on those last 10% that is truly high risk, right? But I also agree on your point around AI. I think there will be enormous attention to what's the decision-making protocol, what's the audit log, or what's going on in those decisions being made, right? In terms of looking at false positives. And there's some questions coming in exactly to what I'm talking to about now, right? Is there anything else than AI and technology that makes it a critical part of being compliant? And can you just recruit your way out of it, right? And I think it comes a little bit down to, again, yeah, you can do one at a time lookups in a sanctions list, right? But you won't be able to do that every day, So again, your quality becomes as good as your technology and your automation allows it to, right? Okay, it's 3 minutes to the hour, so I think we should start to wrap up here, Jens, and saying thank you so much for joining and sharing your knowledge around the regulatory changes, both what's been happening and what's coming, and how does that impact. It's really been a pleasure. I hope we can do it again. Maybe deep diving into UBO thresholds once they get settled. And as mentioned, we're going to share the slides. Also, the recording of the webinar will be on our webpage. We'll link to it so people can see it that weren't able to join today. So I think, Jens, do you have anything else, or should we call it?
No, it's perfectly fine. Thanks for inviting. As I said, I mean, we're going to share not just the slides that we actually showed you, but also the secret slides.
Yes, the speaking notes. Exactly.
With the more granular details.
Yes.
But thanks, Anders. So let's check up on the threshold on UBOs once we know more.
Yes.
So because that
Absolutely.
is going to be quite important.
Fantastic.
Thanks to the audience.
Thank you, everyone. Thank you for joining, and have a wonderful Wednesday. Take care.
Bye-bye.